Welcome once again to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program, as we tell you, has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect your family, your business, and yourself regarding all matters with the law. We continue to provide information and resources that'll help you decide whether you need or want to contact a lawyer. Perhaps you'll determine that you can handle some issues yourself. If you do decide to enlist outside professional counsel, they'll be better prepared, you'll be better prepared, and our goal, of course, is to have you reach the best possible outcome, saving time and money. The Bazar and Associates law firm in East Providence continue to help us with each of the topics that we tackle every week. We want to first thank and welcome Attorney David Bazar.
Thank you,
East
Deb.
Providence. And together we want to welcome our new guest today, who is Raskin, who formed Raskin and Berman in Providence 1984. So we're happy to share with you that the firm has had several times received an award from Rhode Island Monthly for its excellence in law, and they offer, I think it says, 40 years of experience in debt relief, including foreclosure protection, tax liabilities, bankruptcy, and business and consumer workouts. We say this because today our topic is bankruptcy and debts. Yes, we've covered that topic from time to time, but new questions arise now in view of the context that COVID still presents us. With the COVID pandemic, what happens when you're laid off or unemployed because your business is closed down? How do you prioritize that stack of business debts and personal bills, and when do you call it quits? So I guess while we've talked about this before, David and Russ, it's probably a good idea to start by reviewing the basics by the numbers, so 7s and 11s and 13s. What are the basics?
So there are different chapters of bankruptcy for individuals and businesses. And for individuals, basically, as I understand, in Chapter 7 and Chapter 13. And for how those work, I will let Russ give us a little primer.
So Chapter 7 is called liquidation bankruptcy. It rarely results in any liquidation because both state and federal law give you things called exemptions, meaning assets you can keep. And we work hard to, any competent bankruptcy attorney will work hard to ensure that everyone keeps their assets as much as possible. That's Chapter 7. Chapter 13 is a reorganization. That's very helpful when a person, for example, is behind on their mortgage, behind on their rent, doing various things of that nature. We can keep a person in their home even if they're very, very far behind on their mortgage. And there are also, in both Chapter 13 and Chapter 7, mechanisms in the bankruptcy law that we can fight if the consumer needs assistance. It gives us a forum to raise whatever consumer rights they might have and be able to keep them in their home. There are business bankruptcies also. The obvious one is Chapter 11. There's a new subchapter that became effective last February, and that's called Chapter 5. And that's a small business reorganization, also very effective. So far we haven't seen many of them because there haven't been the right cases. I just spoke with the trustee's office recently, and there just isn't that much of a call for it yet, but it's available for a small business if they need help. And then there are state court non-bankruptcy options also. So there are a lot of options for a person, either personally or in business, who needs assistance.
Certainly sounds like that's a good overview. Now overlay that with the fact that we've had a very unusual circumstance in the past year where people have had their lives disrupted, perhaps forever disrupted, by COVID and an inability to work. We've had some things that have helped us, like CARES Act, and some some assistance where you, as a landlord, can't boot your tenant, and there's some forgiveness with utilities. How has all of that, in your view, changed the landscape? And then we'll go to a drill down on some of the specifics. But what has happened as a result of those
Well,
things?
it's quite striking. When the pandemic started, most people assumed that the bankruptcy court would be inundated, and that hasn't happened. It hasn't happened because the CARES Act and other stimulus payments have really kept people afloat by and large. We're not seeing an explosion of people in great difficulty. Of course, hopefully, as the new funds come through, they'll dovetail with the economy growing up again, and then we won't get into a tremendous bankruptcy glut. But so far, the CARES Act and the PPP loans, the EIDL loans, all of these various programs have really gone a long way in helping people stay out of bankruptcy, and then sometimes they've actually improved their financial situation.
Really? Let me ask both of you, David and Russ, have people come to you thinking that they really must declare bankruptcy because they just aren't aware of what goes on, and at which point it gives you an opportunity to say, well, tune in, there are other things, whether you send them to a website or you mail them information or whatever you do. Have you had people come to you, and each of you, and have you tried to reassure them, or have you not had many inquiries at all?
I have had some,
Yes.
not a lot. And as Russ was saying, there's programs. And I believe there's been programs for landlord-tenant cases, and know that there's a lot of pent-up eviction, perhaps,
Yes.
issues. But I believe there's going to be programs where there might be money available to help catch up rent for people if the landlord is willing to maybe write some off and the tenant is willing to pay going forward. Those cases that have come to me, most recently I had one I sent to Russ, which I think is probably people who need to look into bankruptcy, and so I sent them over because I knew they'd be in good hands.
And have you found that there have been many who are just asking about it, that you can then set a right and say, let me reassure you, you may not need to go that route?
Well, bankruptcy is a powerful tool, but shouldn't be used all the time. I would say most people don't realize the tool they have. Most people don't know about the consumer rights they have. And we always, like physicians say, first do no harm. We first try to find non-bankruptcy alternatives if there are. Most people are reluctant to file for bankruptcy, and that's natural. We point out that yes, it's not anyone's first choice. No one gets up in the morning and says, oh boy, I can't wait to file for bankruptcy. But Henry Ford filed for bankruptcy, his companies 2 or 3 times. There are many established companies that started out with insolvency. There's a whole industry of hedge funds and other entities that actually buy bankrupt companies and revive them. So the American system is, we don't have debtors' prisons here. We don't say to a person, you made one mistake, that's it, you're kaput. Instead, we say that you have an option. And you can try and try again. That's the American way. So we just try to give people what the options are. We don't encourage people to do anything that's going to be harmful to them or too expensive for them, and let them make the choice. Often, once you learn the issue and you present it to the client, it's an easier answer. It's often sometimes just a numbers game. How much is your income? How much are expenses? Can you modify those to make it work? Once a person is faced with those numbers, then he can make a decision. He or she can make a decision.
How about you?
I just want to chime in quickly on that. Russ is absolutely right. A lot of people are reluctant to file bankruptcy, and sometimes it's not the option that they need to consider. But many times I would hear people say, I don't want to file bankruptcy because my credit. But they're usually already at a point where the debt has choked them and they haven't paid it and their credit has already been affected. And it would seem to me that by filing bankruptcy, they're going to become a better credit risk down the road.
Yes, that's 100% true. Part of your FICO score is your debt-to-income ratio. And, of course, in a bankruptcy, once your debt goes away, you immediately get a bump up in your credit report. We often see your credit will go up by 100 points a year or so after bankruptcy.
Good to know. Let's give some other practical advice. By let's, I mean you two. When people are at a very difficult point when it comes to paying bills, they're piling up, and let's say it's because of coronavirus for the sake of argument here, what do you suggest to people? How do you suggest that they go about handling it? I'm thinking about at times someone, might be able to negotiate with, but how do you prioritize and what should you do before you get to that point? Not that I don't want to go back and discuss bankruptcy, but what good advice can you give to our viewers?
We have a general rule that the first thing anyone should do is look at their income and project for the future, whether it's steady, going up or going down, and then look at their expenses. That means opening your checkbook, looking at your credit cards or your debit cards. What are we really spending on food, clothing, utilities? Are we spending? Often people will spend money on things and they don't even realize it. I once had a client who couldn't understand where he was losing money. It turned out he was the foreman for a construction crew. And every morning he'd buy Dunkin' Donuts for his crew. When you added it up, it was $400 a month. Now, he didn't even think about it because we had gone through all these numbers. So that's just an example of if we just sit down and figure out what do we need for rent. Our taxes are coming up. Do we have a medical condition that's going to require prescriptions? Do we need both cars? Do we need a car loan? Can we get by with an older car and one car loan? Can we use Uncle Ted's car, even though it's an old car, we don't want it? All of these things, that's something that anybody can do on their own, but it takes an hour or two to pull out the documents, and it's not fun to do, but it's so important. And once you know what your income and expenses are, you can start making decisions.
And then what you have to do after that, because that is absolutely the first step to figure out everything is, then it's discipline to say, well, this is what I need to do and follow that guideline of what you need and what you want and make sure you prioritize it that way.
Do you find that people, when they are in a situation, say with their landlord, and they can't quite make the payment, coronavirus related or not, does it make sense? Is it possible for someone to be able to call their landlord and say, I'm going to be out of work for 3 to 6 months, can we renegotiate? I don't know, a different term, a different payment, I'll pay you back later. Does that make sense before we say, I just can't pay the rent, I know I'm not going to get kicked out, what should I do?
Well, if you've had a good relationship with the landlord and you've been there for a while, communication's always the best thing anybody can do in any circumstances. I even say that with people with their mortgages on their homes. The problem is sometimes finding anyone to talk to and then finding anyone to talk to who has any authority to do anything. But with a landlord, generally, it's a person. And you've been paying this person for 5 years, 8 years, 10 years, whatever it's been. You've got a relationship with them. If you're honest and upfront, and I think they would appreciate that as much as anything, especially more than just not paying. So if you had a situation where I'm on unemployment, my income's been cut in half, if it's okay with you, I'll pay half for the next 6 or 8 months or whatever it is until I get on, and I'll accrue what I owe you, but when I get back on my feet, I'll pay my rent plus an extra $100 or whatever. I'm sure they would much rather have that discussion than say, you're not paying, I have to evict you.
Mm-hmm. Yeah, I agree with that.
Good point. So if someone is unemployed, can they still file for bankruptcy? I know we talked about there's 7, there's 13. Can you reorganize, so to speak, if you are unemployed? Does that actually work out? Or?
That's a good point. There's no financial threshold that you have to pass in order to file Chapter 7, liquidation bankruptcy. In Chapter 13, you do have to have enough steady income from some source or another. It doesn't have to even be a job. It could be, you could be entitled to some funds from another source, and you can use that to fund your payment plan. So in Chapter 13, not necessarily having a job, but having some form of income or funds available would be essential.
And Russ, as I understand it, the way a 13 works is your debt gets put into a bucket, so to speak, unsecured debt, I would assume. And
which
then,
means?
That it's not a mortgage, which is a loan secured by the real estate, or a car loan secured by an automobile. So credit card debt, personal loans, things of that nature.
Unsecured.
So it gets put into a bucket, this is what I owe, and then a plan's worked out where a payment's made to a trustee, right, and then the trustee makes the payments out from there.
Does that absolve that person from paying the bills for some time so that another person that you called a trustee is actually sending out those checks?
Right. The system works, for the typical Chapter 13 will be a person who's 6 months behind on their mortgage, and their mortgage payments are $2,000 a month, so that's $12,000. They don't have $12,000 in their pocket, but we can put them into a 5-year payment plan, a 3-year payment plan. Now that's $150, $200 a month that they can pay off this debt, and that's much more affordable. And we can sort of force the bank to accept those payments over 3 to 5 years. We can then put into the plan any other. So let's just, an example of this person who owes $12,000 on their mortgage. They have a little bit of taxes perhaps, maybe $10,000, $20,000, $30,000 in credit cards. That all gets put into a plan, and the bankruptcy code has priorities of how those are paid. We figure out what's the essential minimum we must pay, make sure there's enough income for that. And then if they don't have enough income, that's when we start talking to them about what I talked to you about before. Can we increase our income? Can we decrease our expenses? Can we shift this around? Can we do what's necessary? And then once those numbers, once we're aware of those numbers, the answers come more easily than you might expect.
Help us understand, use your figure of $12,000. When someone is going to reorganize, it's all about the payment, just when, as if you were getting a car. It's not about what the car costs, it's what the payment is. Can we fit you into the payment? Ultimately, what other fees, or what is that actually going to cost someone, even if it's strewn out over time? If it's $12,000, a trustee, a lawyer, interest, what might it look like?
Well, it's kind of complicated because there's a whole bunch of things that go into it. One are the attorney's fees.
Sure.
Most Chapter 13s, it can be expensive. However, you can put those fees into the plan. So for every $1,000, for example, that a person might owe his or her attorney, that's around $18 a month that gets added to the monthly payment. So it's not terribly, it's not a terrible, it's workable. Mm-hmm. So no one should feel uncomfortable about considering Chapter 13 if they don't have a lot of money, to pay their attorneys, which they're not likely to have. In terms of how you figure the plan, the numbers that come off the top are about 10% to the trustee. That gets varied, but roughly 10% to the trustee, so that has to be added to your payment. Attorney's fees, taxes, certain kinds of taxes actually can be discharged. Certain kinds of income taxes if they're old enough, but if not, those have to be paid in full. And then the unsecured creditors get whatever is left over. And then we figure out what your income is, we subtract what your monthly expenses are, and that number at the bottom is your monthly payment. And that monthly payment has to be enough to pay what I just said, and we also have to be sure that it's sustainable.
That's an interesting point, sustainable. So I can't necessarily know that 2 months from now, even though this looks good now, 2 months from now, suppose new medical bills come up, then what happens? Do you go back, does someone go back to you and refigure it?
Yeah. Yeah. Throughout, especially any kind of long-term plan, there's always ups and downs. And the code has a mechanism of amending the plan, and the court is very amenable to that. And once you demonstrate to them what the change in circumstances are, as long as you follow the rules and can fit it within the code's requirements, you shouldn't have any trouble amending to take care of a situation like that.
What happens with garnishment, David? As a creditor can glom onto some account, how does that work, and what can't they
So there's
access?
certain things that can get garnished, and so if you owe debt, I'm going to use credit card debt in this instance. The credit card company can't call you up and say, where do you work? We want to garnish your wages. They have to sue you. And then that's case against you either has to get tried, or if you don't answer, which is the worst thing you can always do, you get defaulted, they go to court, and then they bring you in what's called supplemental proceedings, and the judge says, where do you work? And they ask for a garnishment of your wages. So when someone comes to me with something like that and they have all of this debt and all these issues, I would say, call Russ. You need to talk to him, because if he files bankruptcy, there's an automatic stay on those lawsuits where people are trying to sue you for the debt that you owe them.
Is that of value just to have the harassment stop?
Well, that's interesting you ask that, because there are sometimes we'll say to a person, you don't have that much debt, and you probably could work this out, and they'll choose to file bankruptcy because they're so rattled by the calls. The credit card companies, these unsecured creditors, don't have very strong legal rights. They'd have to sue you to do anything, and then they have to hire an attorney, then it costs them something. So they'd much rather try to induce you to do things voluntarily, and they've got an excellent system of making people crazy with the phone calls. They're allowed to do phone calls between a certain period of time during the day, but they can really tug on the heartstrings and make you feel very bad, and people may file bankruptcy just to relieve themselves of that pressure.
What do you say
Well,
about that?
there are rules theoretically of what they're allowed to say and when they're supposed to be allowed to call and all of these things. And I'm not sure that they always follow the rules. And I've had clients come in and say, they told me they're going to come to the house and do this or they're going to do that. And can they do that? And of course the answer is no, they can't do that. But what do you do? Who do you call to complain about it? I'm sure there's a consumer line or
There
something.
are laws. You can fight back against that. But once we explain that it's all bark and no bite, usually it's not worth paying someone. There are firms that really specialize in that. So if someone really is being harassed, there are some cases that a person could actually get remuneration for that.
Good to know. When it comes to people having retirement accounts, should those be kept separate and apart when you have to make the determination of whether or not someone should file for bankruptcy? So in other words, maybe I have an inordinate amount of debt right now, but if this is done in 10 years and theoretically I could be working, might I want to leave that retirement IRA, SEP, or whatever untouched because it's going to be penalized? I might not be able to have it accrue interest again or whatever else I would like to do for my future. How do you counsel people with that? What do you say?
I think you've asked a good question that leads a little bit maybe to what exemptions are and what's subject to liquidation in a Chapter 7 bankruptcy or liquidation. So.
Yeah, that leads me to Russ Raskin's rule number 1.
Uh-oh, pay attention.
Don't use your retirement funds
Ever.
on your debt. Just don't do it. Why don't you do it? First of all, it's for your future. And whatever pressure you're facing now is today, and it's going to be over it. Some way or another, we're going to get past it. Don't give up your future for today. Secondly, if you take money out of a retirement plan that you didn't pay taxes putting money into, for example, non-Roth IRA type items, then you're going to pay taxes on it when it comes out. And many people won't do that. Now you've got a tax liability. So please don't follow Russ's rules. Don't take money out of your retirement fund. That's for your future. If you find you're doing that, then come see someone right away because you're making the wrong step and you're harming your future for
Russ,
today.
are retirement plans exempt somewhat from?
Retirement funds, I should have said that, thank you, David. The retirement funds are almost always completely exempt from attachment.
Oh, so we should know that right up front.
That's
and it
right.
becomes
So they're
a
always
non-negotiable
your
issue.
IRA, your 401k, your 403b, the 457 plans, TAA, CREF, all of these things, retirement pensions, they are exempt from attachment. They cannot be touched by your creditors.
What about the money that you're given by the wonders of coronavirus and the CARES Act? Where does that go? If it goes to my general checking account where my creditors might have access, can they glom onto, garnish that? Or does it go to a separate account that everyone else has hands off? How does that work? Or what should we do to avoid the problem?
Well, you've actually hit on an issue that's unresolved.
Okay.
The bankruptcy code was amended to provide that PPP money under any kind of stimulus act is not counted when we count your income and your assets. However, there's a loophole, and that is the code never stated that when the money hits your account, it's exempt, just like a retirement fund would be. The United States Trustee's Office has made a policy decision to not pursue those kinds of funds except in egregious cases. So we don't usually see those sorts of things. So I would say probably they're safe, but technically they're not.
Good to know.
So how would you physically or mathematically do that? So let's say you have an exemption for your bank account, whatever it might be. And then you get the $1,400 check. Do you think you could argue that, well, I have my exemption for the money in the bank account plus an extra $1,400
Yes.
for that money that went in?
Yes, we would do an analysis. So we'd look at the bank statements and find out how much money there is, and we'd figure out how much exemption we have. And if it's over that, we can do certain things to help with that. We're not seeing a lot of people stockpiling their PPP money.
Yeah.
It comes in and it goes out. So I haven't seen that down.
And technically, for a business, it's really designed for payroll. So it comes in, you're supposed to be using it for payroll.
Right.
So it's going to go out either every week or every 2 weeks usually.
Right. I think I agree with that.
And what do you say to a couple who are planning a divorce, other than, gee, Russ, do I get this as a 2-for-1, and do we both declare bankruptcy and we pay one price for the two? What do you say to couples who are separating and divorcing under these circumstances?
The interface between domestic relations law and bankruptcy law is complex. There has been an increasing restrictiveness imposed on the bankruptcy code over the years to prevent child support, alimony, domestic relations types of things from being affected by bankruptcy. So once there's an order from the family court, bankruptcy often will not be able to affect it, and you have to sort of take it as a given. It's almost sacrosanct. There are exceptions and so forth that we can work within, but generally speaking, if the couple is amicable and wants to work things out and not have both of them liable with things afterwards, it may be safer to file bankruptcy together first. And the reason is there's only one case because they're still married, so you don't double the attorney fees, you save on attorney's fees. And secondly, you take care of all those things. Instead of having a divorce decree that says husband will pay for this after the bankruptcy, after the divorce, wife will pay for this after the bankruptcy, after the divorce, it gets mixed up because then what if they don't pay it? Now you're back in family court fighting over that. So it sometimes does make sense. And we get calls from 2 divorce lawyers who will say, would you have a consultation with our clients, please, and just tell us whether it would be worthwhile for us to resolve those financial issues first and make the divorce easier.
And Russ is 100% correct. That's the best way to do it, because otherwise you're subject to the drafting abilities of the family court lawyers to protect the person who didn't file bankruptcy from having to pay the debt that was supposed to be paid by the person who did file bankruptcy, and that comes up often.
Good to know. We certainly have covered many and various topics that we hadn't in the past. Thank you so very much for joining us today. We thank you for staying tuned to the Law Matters. As we say, it matters to you.